Hi, everybody. My name is Katie Kestner, and I am the Executive Director at the Take Back the Night Foundation. We are the oldest global movement to end sexual violence in all the world. We've served millions of folks in over 40 countries. We hold events, rallies, marches, global virtual events for anyone to join. We welcome you to get more involved. But today we're going to talk with our legal team. They're going to walk us through exactly how this civil process of justice works. And I'm pleased to have with me my co-host, Amy Tilton. Amy, could you introduce yourself?
Sure. Hi, my name's Amy Tilton, and I am the Assistant Director at Take Back the Night, and I've been working closely with our legal team this year. So, Katie, who would you like to turn our first question to?
Yeah, I think we're going to go from start to finish. So maybe we'll start with Marlo, if that's okay. Welcome, Marlo.
That would be great. Thank you so much, Katie. Thank you guys for having me. I really appreciate it. My name is Marlo Greer. I work at the Greer Law Group, and we handle sex assault cases nationally. What I tell people is one of the hardest things to do is pick up the phone. And it's free to pick up the phone. It's private to pick up the phone, and it takes incredible courage to do so. So one of our most important things is what we call the intake process. When we do get the call, you can call Take Back the Night and do the initial process. You're going to be asked a handful of questions. It kind of varies the questions that are asked. I'm really sensitive with my survivors as to what questions they want to answer. Of course, we need certain basic information: when, where, and what happened. But I don't make people go into incredible detail unless they want to. So we really try to be victim centered, but the most important thing is being able to pick up that phone, so that we know that you've been hurt and that we can help you.
Yeah, that's lovely. I think it's so important what you just said, Marlo. It's like we sometimes just need to start, and the phone call is the hard part. But hearing someone say, "How can I help you?" sounds magical. That's like, how who gets to hear, "How can I help you?" And there's no strings attached. Like, it's the most fabulous, liberating. Even if that's all you get is, "How can I help you?" Don't forget that there are people out there you've never met, never spoken to, and they are here to help. And sometimes we get so in this box of like, I don't know how to escape. My PTSD is driving me crazy. I want to numb out this pain. I can't get rid of nightmares. And I love the idea that talking, and you're looking at the screen full of amazing attorneys, and I think they're all very happy and healthy and like ready to go. I can't speak to their own situations with their pet trauma or family drama, but I definitely know that they put on their best hat when they answer those calls and talk to you. And luckily, they work with teams, and they all get along, and they all are willing to cooperate and put the best person on the phone with you as a survivor. So thank you, Marlo. That was super. Go ahead, Amy.
So, I have a question for the beginning of the process. If I'm a survivor and I'm a student or I'm living paycheck to paycheck and I'm really nervous, like, aren't lawyers expensive? How am I going to pay for this? Is there any answers for that?
Absolutely. There's answers for that. And I don't know if you wanted me to take that as well. Katie, one of the things that you said that I feel is important as far as somebody saying, "How can I help?" But also, we believe you. And part of we believe you is I tell my potential clients and my clients, I'm all in if you are all in. And by all in is that the majority of us that do this work do it on a contingency fee basis, and you do not need to pay us anything up front. Nothing for the investigation. You don't need to pay attorney's fees, none of that. And you don't have to pay unless we're able to recover something from you. And so that's really part of me saying, I believe you and I am in your corner and I'm willing to show you by waiting. And we're not going to take any money from you until we can do the right thing by you.
Awesome, Marlo. Well, let's take it to Guy, DeAndrea. Guy, so now we said, yes, I'm going to help you. What happens next?
Sure. Thank you, Katie and Amy, for having me today to discuss this topic. My name's Guy DeAndrea, as you said, I'm co-managing partner of Laffey Boosie Law out of Philadelphia, but we practice nationally. And so to that question, though, what's next? So if the client ultimately decides, yes, this is the process I want to go through, So we begin, at least how we do it, is we send out a welcoming packet that has, and it's large, and but it's important in terms of the information. It details every step of the process because we explain that verbally. But what we recognize from so many trauma survivors is that, okay, I just listened to a lawyer like sort of speak at me for an hour, and now, but I just talked about my abuse and my assault. And so what the heck did he or she just say to me? Because I don't remember. And so it's really important to make sure everything we say to a survivor is also then sent in a corresponding messaging so that they also have something tangible to look at. And so the next step that we would see is, of course, we would file a civil lawsuit, which is called a complaint. We largely take care of that. The client has to make sure the facts that we say are true to the best of their knowledge. But then the real significant point that the survivor would be involved in, and I'm skipping a couple steps because it's important to know about what's important to most survivors. And the next major stage for a survivor is what's called the discovery period. And that's where there's a written portion to it and then an in-person, we'll call it, portion. And the written portion is written questions that are sent to the survivor, but through us, right? So we sit down. These are sent by the defendants, but you're not being questioned in person yet. We're going through those questions with you. We're listening to you. We're putting what you say down, but we're also putting it through the filter of a lawyer's mouth, right? In other words, we're putting our legalese on it or objecting to certain questions. And then the next significant stage for a survivor, anyway, is the deposition. And what's really important is that you are thoroughly and properly prepared to testify. It's not like you see on television, right? Or at least if you're with a trauma-informed firm,
Yeah,
meaning
I'm thinking Angela, her Depp case. I'm like, oh my gosh, what
it's
outfit,
in,
where wardrobe, makeup?
oh,
Like it sounds intense, Guy.
I'll
Can
tell you
you
right now.
explain that?
Yeah. So we prep with our clients extensively, and I tell them in every prep, we can't promise what questions are or aren't going to be asked or how invasive they will or won't be. But what I can promise you is no matter how invasive the question is, they will ask it respectfully. If they're going to yell, if they're going to curse, if they're going to try to berate you, we will walk out. And if I get sanctioned or fined by the court, so be it. I am not going to let any one of my clients be spoken to in a disrespectful manner. I appreciate that defense attorneys have a job to do, and I will let them do that job. But just like anybody else, they can do it in a respectful manner, in a way, and in a tone to get the information that they may need to defend their client. So I always want clients to know when they're walking in, it's not in a courtroom, it's not in front of jurors, it's in a conference room. We're there to protect you. We take a million breaks. Even if you don't need one, I'd say, don't stop. If I say we need a break, we're taking a break. And that's like a really significant moment in the case. And there's so many other stages, but clients always ask me, survivors, like, what do I have to do? And the written discovery and the deposition and meeting with some psychologist or psychiatrist who are the experts who are going to put your trauma into medical language. That's really the three major stages in which a survivor, I'll say, has to participate, right? Because the survivor's in control. Some want to know everything every day. Others are like, Guy, call me when you absolutely need me. Otherwise, you go do your thing, right? And it's everything in between. And just making sure that you're with a firm that meets you where you're at and what level of what you want in terms of information, participation, et cetera. Again, there's things you have to do, but then there's you tell the lawyers what you want in terms of your involvement otherwise.
I love that. Thanks so much, Guy. I think that was really affirming as well to anyone listening who was worried. And please know, our listeners, like, you're looking at the real people. They're not actors. This is not acting. These are the real people who, I mean, they look great. I know. Look at the
No, I had
coolness
no
on
hair
the
and makeup.
screen.
I had no hair and makeup. I think it's very
No
obvious.
You
hair
had
and
plenty
makeup.
of makeup.
But
You definitely had your hair done today too.
all right. And plus, they all know how to joke in an appropriate way. So you're in excellent hands around here. That's one of the joys of the work. It's hard for all of us to work with survivors, but it's wonderful to be able to work with people who have such incredible integrity and care and concern for people who've been hurt and helping them get through that process. So let's talk next phase. Michael, so we've done all this work. We went to trial. We gave it our all. Then what happens next?
Well, hi, Katie. My name is Michael Nimmo, and I'm an attorney in Denver. But like Guy, I have pretty much national practice as well, representing survivors of sexual abuse. So you go through the trial. What happens next? So I guess if you go to trial, and you could go to trial and win, or you could go to trial and lose. If you go to trial and win, you have what's called a verdict. And after a verdict, there are several things that could happen. One is there could potentially be an appeal of your verdict, in which case you would not get paid on your verdict until the appeal has been finalized. If there is no appeal, then the judge will enter judgment related to cost and fees associated with the case, and then a check would come, and the defense attorney's firm would pay, through their firm, they would pay the defendant's share of the judgment to the lawyer, to the survivor's lawyer. So if I was the attorney, the check would come to my law firm. It would go into a trust account that's regulated by the state of Colorado, state of Texas, whatever state I'm in, and then the attorney would distribute the money to the survivor. So that's how it happened with the judgment. There's also another avenue, which most cases actually don't go to trial and they don't end up with a judgment. Most cases settle. And they may settle after filing a lawsuit or before filing a lawsuit, but oftentimes there's a settlement because trials can be very traumatizing, and they're long and they're hard to go through, and there's no guarantee you're going to win. And so settlement is oftentimes the best option. And with a settlement, there's what's called a settlement agreement. And the settlement agreement is a written document that is prepared by the lawyers for the survivor and the defense attorney that lays out the terms of the settlement. And sometimes in the settlement, there is confidentiality. And the confidentiality clause means nobody gets to know about what happened with the survivor. Nobody gets to know their name. Nobody gets to know what the amount of the money was. Sometimes I have survivors who don't want confidentiality because they want to be able to share their story, and they want to be able to say, look, this happened to me. And in those cases, that's a negotiation that we have with the defendants and the defense attorney about no confidentiality in the settlement agreement. So those are terms that can be worked out between the lawyers of the survivor and the defendant. But once you get to a written agreement, the survivor signs the written agreement saying, I accept these terms. And then within usually 2 to 3 weeks, a check will come to the attorney, and it'll get deposited into the trust account. And then that money will then get distributed to the client based on the terms of the settlement agreement.
Nice. Thanks so much. So we round the Amy, did you want to go back to anything so far before we hit what happens if it gets appealed?
Just to give survivors a
Yeah.
sense of how long are we talking from the point that someone first makes the phone call all the way until we're at maybe an appeal or maybe a settlement agreement or a verdict.
Amy, you're not going to like this answer because you've heard it a bunch today, and that answer is it depends. Every single case is different. And I would say that, the general life cycle of a case from start to finish is on average 12 to 18 months. It can be longer, it can be shorter. There are some cases that resolve pretty quickly, but that's not normally the case. It normally takes a little bit of time. There are some cases that drag on for a very long time for one reason or another. The judges typically set cases for trial within a certain time frame from the date you file, and every state has a different rule when it comes to that. Like Colorado, where I'm based, it's 12 months. The judge has to set the trial within 12 months from the date of filing. But then sometimes cases get continued and they get reset. So these things can drag on 2-3 years potentially. But generally, I would say within a year to 18 months, the case should be in a position where there's a resolution to the claim. It also depends on how big of a scale the case is. So sometimes we have cases where there's numerous survivors that were abused by the same defendant or the same entity that employed the defendant. And in those cases, they typically take longer because you're dealing with many more survivors and many more claims. And those cases usually take multiple years to resolve. I've had a recent one that took 4 or 5 years, but there was over 1,000 victims involved in the case. So it really depends on what the case is like and who the defendant is and how much work has to be done to get it to a point where it can settle or go to trial.
Thanks. So let's close this conversation with the appeal, and I'll head to Allie. What does that look like? And welcome, Allie.
Thank you so much for having me, Katie and Amy. My name is Allie Solpin. I'm joined here similarly like my colleague and friend Guy D'Andrea from Laffey Busey Law. With regard to an appeal, it's a road that as a survivor you don't want to go down if you're on the losing end of it. And I say this because you've already gone through so much to even get to the point of having the courage to make the phone call that Marlo talked about, to go through the discovery process like Guy talked about, and to potentially sit through a trial or mediation to lead to a settlement that didn't happen or a verdict that didn't happen in your favor, like Michael talked about. I was a former appellate law clerk, and I can tell you that most appeals are, I would say, 95% of them are unsuccessful. And the reason why I say this is not to be upsetting, because on the other side of it, you could have the defendant appealing, which means that your verdict is upheld, right? So there's two sides to every coin. I say that because of the fact that when you sit in a courtroom, if you're in front of a judge and in front of a jury, the jury is there to make findings of fact, the judge is there to make findings of law. If you are going to make an appeal, you generally, more often than not, can only make appeals regarding the findings of law the judge made. And the appellate court, which is the court above the trial court that would be overseeing this, is extremely deferential to the trial court and the decisions the judge has made. With that being said, there are certain things that come into play that would lead to a very clear appeal in my mind. Number one, it's called plain error, when the judge makes a finding that is completely unsupported by the laws in your jurisdiction. We all have horror stories from law school that we learn about where some judges are truly asleep at the wheel and they make a decision that is not supported by the law of the land that they are governing. That would be something that would certainly be overturned. Another thing, and it sounds silly, that generally go up on appeal are jury instructions and also the composition of jurors. We have a lot of case law that talks about the different jury instructions that are given to juries in order to help them make these findings of fact. And if the instructions are unclear or prejudicial, that is a basis for appeal. Another one is you're entitled to have a jury of your peers. I use this as a hypothetical. If you are a minority defendant, a minority plaintiff, and your jury is full of people who are not minorities and the opposing side has stricken every minority that came up, that is certainly a cause for concern that you did not have a jury of your peers. So, with that being said, I know for a fact that Guy is a trial lawyer. I am a trial lawyer. If you are going to go through an appeal, I would recommend that you talk to your lawyer, your trial lawyer, about consulting an appellate lawyer, because the standard of what you have to do by way of filing a notice of appeal, the timelines in which you have to do it, the briefs you have to file, you're also removed to a different court now. You don't want to forsake your rights to appeal by putting your faith in someone who this might not be their wheelhouse. Certainly, your trial lawyer is going to be sophisticated enough to put you in touch with someone either in their practice or they have a relationship with. But it's definitely important, like we've talked about today, to consult an attorney to learn about your appeal rights. And if you're on the other side where the defendant is appealing a verdict, just know that that's not a bad thing necessarily, too.
Thanks so much. That was really helpful. All four of you. I feel like we took a fast course through the whole process, but I think if anyone's eager to learn more, they know where they can find you. But for our listeners and Take Back the Night fans and members, I just ask you to have courage and have faith, and that the process can work. It really can, especially when you have someone as gifted and talented as our legal team. So, Amy, do you want to remind everyone about the hotline?
Sure. Our National Sexual Assault Legal Hotline is run through Take Back the Night Foundation, and it's a free resource available to all survivors. And we encourage you can either call 567-SHATTER, the phone number 567-SHATTER. And so you can talk to someone who has been trained and is willing to hear more about your story, or you can complete our online intake form, which asks some questions about your experience, and someone will be back to you within a few days. So either way, we have an experienced legal team who will be getting back to you. So you don't have to call and fill it out. You can do one or the other, but we have a great resource for you to learn more about your legal options.
Thanks so much, Amy, and thanks to all of our guests today. And just as a reminder, we have others in this series about our legal support team and justice. We'll have one on victims' rights and one about the different systems of justice. So please look for those if you have more time and inclination to learn more. So be well, take care, stay strong, and keep the healing going.